Get ready for the dictation in 3, 2, 1, start. The Article 226 of the Constitution of India, by its nature and object, is wide enough to include within its sweep all the conditions like manifest arbitrariness, reasonableness, natural justice, and all other concepts which constitute the basic structure of the Constitution, and the High Court has power to issue writ or direction for not only enforcement of fundamental rights but also for any other purpose. Stop. Counsel argued that a citizen has a right to approach the High Court for implementation of the rules framed by the state government, and if the state government acts contrary to its own rules and regulations, then the High Court cannot become silent spectator and its power cannot be curtailed by any law. Stop para. The Constitution of India, being a living document, and framers of the Constitution, considering diversity of the nation, has given such powers to the courts so that no litigant can be left remediless. Stop. In order to maintain purity of election, judicial review is essential and there cannot be any ouster of extraordinary jurisdiction of the High Court, and in particular if the High Court does not interfere, the purity of election would be at stake and the same cannot be countenanced in democratic setup of this country. Stop para. In view of the interpretation made by the apex court in the case of Keshwanand Bharti versus State of Kerala, reported in AIR 1973 SC 1461, the Article 329 of the Constitution is part and parcel of the Constitution of India and forms basic structure of the Constitution of India, and since provisions with respect of Article 243 have been incorporated vide 73rd Amendment to the Constitution after the decision of the apex court, the judicial review is a basic feature of the Constitution, and as such the bar has to be understood to be against ordinary courts and not against constitutional courts. Stop para. As per the decision of the apex court in the case of Election Commission of India versus Ashok Kumar, reported in 2008 SCC 216, rendered by the larger bench, the power of High Court cannot be denuded in the election matters. Stop. Per contra, Ms. Sheetal Mirda, Additional Advocate General, has raised following submissions oblique objections. There is a complete bar under Article 243(o) of the Constitution of India, which has been inserted in Chapter 9 of the Constitution by 73rd Amendment, and the same is analogous to the Article 329 of the Constitution of India, which bars the courts to entertain writ petitions. Stop. The delimitation exercise conducted pursuant to Section 101 of the Act of 1994 and initiated wide notification dated 12/6/2019, which culminated into the final notifications dated 15/16/11/2019, 1/2 12/2019 and 12/12/2019 ought not to be interfered with by this court. Stop para. The exercise of delimitation and subsequent allotment of seats to such constituencies which have been delimited is an exclusive function of the state government which does not infringe or cause legal injury to any individual right of any citizen, and when no legal injury has been contemplated, no remedy has been provided for challenging the action of the state government. Stop. The delimitation does not interfere with individual rights of the citizens, and any proceedings undertaken by the state government in furtherance to delimitation is not amenable to judicial review under Article 226 of the Constitution of India. Stop para. The apex court, while interpreting the scope of judicial review under Article 243(o) of the Constitution of India, the case of State of UP and others versus Pradhan Sangh Kshetra Samiti and others, reported in 1995 Supra 2 SCC 305, has laid down the law that neither the delimitation of panchayat area nor of the constituencies in the said areas and the allotments of seats to the constituencies could be challenged, nor the court could entertain such challenge except on the ground that before the delimitation no objections were invited. Stop. Thank you.